proposing adoption of the agenda. Thanks.
Yeah, any seconder? Hey, honorable members.
I'll second the agenda,
Second.
Chair Alexandra Abrams.
It's okay. Who's that? Is Honorable Abrams? Am I right?
Correct,
Hey.
Chairperson.
Honorable member. Yeah. Any? Do we have any honorable members? Is proposed and seconded, and adoption is proposed and seconded. Any queries about the agenda, honorable members? In the absence of that, can I proceed? Is SALGA ready? Lindwe?
Yes, Chair. There are officials from SALGA. Can I request the committee before we proceed just to register or record the apologies of the committee? I've got 3.
Oh, my apologies. Of course, there's a standing apology of Honorable Ngwenya, which must continue to wish her to get well. Proceed. What are the apologies?
We have a member Silkers is still not well. She is also attend her apology.
Oh, sure. Okay, sorry. Yes.
And member Ngulangulu, she is busy with other engagement, but she will join the meeting at a later stage. In case she didn't make it, what
is other engagement with Bilangulu now? Did she tell you?
She said she will join us later. She didn't mention what is it exactly.
No, but what does she mean by other engagement?
I don't know.
Oh no, maybe
she will join the meeting later.
No, but maybe let's respect that, because she's not a person who doesn't attend committees anyway. Hey, honorable member, can I table apologies?
I would like to adopt the apologies, Chair.
Hello?
I'd like to adopt the apologies.
Who is speaking now?
It's Bridget Masango speaking.
Okay. And the Honorable Stock is seconding, am I right?
You are absolutely spot on, Madiba.
Thank you very much. The next item, Lindwe.
The next item is the presentation by SALGA. Thank you.
All right. SALGA, can you SALGAize us? We're in your hands.
Now, thank you very much, Honorable Chairperson. Thank you, Chair. I don't know whether I'm audible enough. Can I proceed?
You are audible as long as you are audible as long as you tell us who you are.
Okay. No, thank you, Chair. My name is Councillor Chester Seidel. I'm the NEC member for SALGA, responsible or chairing the working committee responsible for community services and social cohesion. I am not alone, Honorable Chair. I'm with my team, the technical team from SALGA. I have with me Mr. Kolisa, who is the Chief Officer for Infrastructure, Delivery, Spatial Transformation Services and Inclusivity. Also with me, I have Ms. Makanda, who is our portfolio head, responsible also for community services. I have Umandu, who is our specialist advisor, responsible for social development services. And lastly, I have Usketo, who is our specialist advisor for municipal health services. Honorable Chair, having said that, let me firstly, Honorable Chair, appreciate the opportunity given to us as SALGA to be part of this engagement today, where we'll be looking into the amendment bill in terms of the children's rights. Honorable Chair, I must indicate before I zoom into the presentation that as SALGA, it has always been our attitude or take that we be given a platform to also engage on any legislation, bill, or policy at an initial stage that is to be implemented in our respective spaces, Honorable Chair. One really appreciates that this morning we are going to be making our input in as far as the amendment bill is concerned, which we feel, Honorable Chair, it is going to assist us in implementing issues around the healthcare facilities or the ECD centers that we have to play a role in as far as our mandate in terms of local government is concerned. In terms of the invitation that we've received, Honorable Chair, indeed, there are 4 areas that you wanted us to comment on or make input on that we are going to concentrate on, but as well as also acknowledging that we derive our mandate in terms of the Constitution. So we are also going to make an input or flag on that, as well as elevate those objects that warrants us to respond to the area of work in which we are going to be really making our input on. If you permit, Honorable Chair, probably allow our Chief Officer, Mr. Kolisa, to take us through what we have prepared for the Portfolio Committee this morning. But we really once more want to appreciate, probably I have forgotten to also greet the honorable members of the Portfolio Committee and those that are present on the platform. Thank you very much, Honorable Chair. If you permit, Mr. Kolisa will take us through the presentation. Thank you very much.
Let that happen.
Thank you, Honorable Chairperson of the committee, honorable members of the committee, and Honorable Councillor, leader of the SALGA, responsible for the portfolio. I was hoping that I would be able to share a presentation from my side so that I could control it. I see somebody else has already shared a screen. If I may be allowed to project from my side. I think screen sharing has been disabled.
But we can see the document unless you are unable to control it where you are. Can somebody do it on your behalf? How do we handle that?
Sorry, can I just try to ascertain who is sharing currently? Because I just Nozbele. Can you stop sharing so that Mr. Collins can share from his side? I made him a host.
Unozbele is Honorable Makanda.
Yes.
I am unsharing, Honorable Chair.
Thank you.
I'm not
I'm
Honorable
sorry.
Makanda now.
Oh, you are not?
Not anymore.
You're a staff member.
Yes, Chair.
Okay, my apology. I'm outdated. All right.
Thank you. Did I unshare?
Yes, thank you so much, Ms. Makanda.
Thank you. Okay.
Yes, Chair, but I think she is still honorable, even though she's a staff member. We see a lot of honor. Thank you. Chair, as the chairperson of the working group has indicated, we thought maybe in situating our presentation, we should just talk briefly about what informs what we see as a local government mandate in relation to early childhood development or child development in general. that, first of all, municipalities have a developmental mandate in general. It is stated, as I will indicate, in the Constitution, that broad developmental mandate, which then includes all members of society, including children. The second one is that within the context of that developmental mandate, we also have an obligation as part of the Constitution to make sure that as a state institution, we also act in the context of the Bill of Rights, which also encompasses the rights of children of all ages. That is a broad context, but in more specific terms, that developmental mandate of local government is enshrined in Section 152 of the Constitution, which is of relevance here.
Who is presenting?
Mtobeli Kolisa is presenting, Chair.
In this committee, we don't mind seeing you, Mtobeli, unless you've got a problem of being seen.
Oh, I thought you will see the screen. Okay, let me.
No, I'm saying. No. It's nice we are seeing the presentations, but we say, is your camera on?
I'm trying to find out, Chair.
You can proceed and present, but it's not an essential thing. We say if it's not, it doesn't cause any problem, we would like to see you. But if it's problematic, you can proceed.
I will activate it, Chair, in the course of time. Maybe I should not take
yes, but continue presenting. Yeah.
Thank you. Can you still see my screen still?
Yes, we do.
Yes. Okay. So. So I was saying then in the context of our broad mandate, we thought we should highlight the social and economic development responsibility of local government, that we are supposed to promote social and economic development. Also, we are supposed, in the way we do our work in general as local government, to must promote safe and healthy environment. And we think that those two have particular relevance to the work that is related to this particular proposed bill and the Principal Act.
Let me check it. I'll allow her.
Then also, more specifically, in the schedules of the Constitution, Part 4, Schedule 4, Part B of the Constitution lists specifically childcare facilities as a local government function. So in that way, local government has a lot of relevance. This is important because the bill proposes that a section be inserted in the Principal Act, and that section that will be inserted is the Early Childhood Development Center section of the Act. It will be inserted as Part 2 of the Act. Is that my video? Okay. In our view, as SALGA, it appears that that section that is being inserted in the Act by way of this amendment, which is called Early Childhood Development Center, is essentially a section that deals with child care facilities. So in a way, it is dealing with the local government function as stated in Part B of Schedule 4 of the Constitution, in a way. Currently, municipalities in performing this function have tended to focus on 3 areas: the implementation of structural health and safety standards in child and youth centers, and then partial care facilities, including ECD facilities. Then also, we have been doing inspections with regard to public facilities, and that includes ECD facilities. We have been doing the provision of infrastructure for registration, support, resourcing, monitoring of ECD services, where some municipalities have capacity to do so, and also provision of direct and contracted services into these functions. This is what we've been focusing on. The point we're making here is that this is a function that is allocated to local government, at least this part of the Act that deals with early childhood development. We acknowledge that the overall thrust of the Act in terms of issues that are related to children is part of what we can call a social services function, which is a concurrent function of provincial and national government. However, the element that deals with facilities is an element that the Constitution pulls out and put in the schedules as a local government function. Now, there's a reason why I'm emphasizing this point. Oh, it's not paging down. I don't know if my presentation is not moving now. Something has happened when I shared my screen.
What happened? What happened? What happened? Technology? Is it your technicians or our technicians?
I think there was something popped up for me to share my screen to show my face while I was presenting. I think it changed something a little bit.
Maybe if your camera is wrong, you can switch it off. If it's the one disturbing.
I think it has moved now, Chair. Let me see. Yes, it is moving again.
Okay. It doesn't want us to see you.
Okay. So in relation to this very specific issue then, Chair and members of the committee, we would like to make the following comment as an organization. We think that to the extent that we've made the point that a section of the proposed bill will affect the status, the institutions and powers and functions of local government, it should then be treated in terms of what is stipulated in section 154 of the Constitution, and in particular, section 154(2) of the Constitution, which reads that draft national and provincial legislations that affect the status, institutions, powers and functions of local government must be published for public comment before it is introduced in Parliament or provincial legislature in a manner that allows organized local government, municipalities and other interested persons an opportunity to make representations with regard to the draft legislation. Now, we want to register in Parliament that we, as the NEC member of SALGA, Councillor has indicated, that it is for the first time as SALGA that we are engaging with this bill here in the Portfolio Committee. As far as we know as SALGA, the bill was never published for public comment in a way that allows organized local government and municipalities to make representations. To that extent, we think that the introduction of this bill is procedurally unconstitutional, because it has forced us as SALGA, after receiving an invitation about a week ago, to quickly put together a presentation without an opportunity to send out the bill to all municipalities and for all municipalities to give feedback that can be compiled into a proper representation that can be made before the bill comes to Parliament. We want to register that. Then the other point we want to comment on in relation to the bill is now the part of the section that is being introduced by the bill, where it is introduced after section 103 of the existing Principal Act. There is a proposal that part B be introduced, and it will be titled Early Childhood Development Center. In that section that is being introduced, 103A states that the MEC for social development may, from money appropriated by the provincial legislature, provide and fund early childhood development centers for the province, taking into consideration the national norms and standards contemplated in the other section of the Act. Now, the point we want to comment about here is that Section 154 of the Constitution states that national government and provincial governments, by legislative and other means, must support and strengthen the capacity of municipalities to manage their own affairs. or to exercise their powers and functions and perform their functions. Now, to that extent that there's that section that says so, we think that this provision that makes for the MEC to assist with funding should in fact include an insertion that will make a provision for that funding to be directed to municipalities or as a form of support to perform this constitutional function of local government, as opposed to what we anticipate could be a situation where, as is indicated in the following sections of the amendment bill, could be an indication where anyone else can access provincial funding for this purpose without necessarily the municipalities being supported to perform this particular function. That is one specific area that we are making. The second one, in relation to 103B of the bill that proposes the amendment of the Principal Act, states that the minister, after consultation with interested persons and the relevant ministers, must determine national norms and standards. Our comment in relation to that, we think that this is an opportunity to entrench IGR, something that has not been working very well, as you can see from our previous comment. Something that has not been working very well in this particular sector. We think that we need to entrench it by way of inserting a specific requirement that the consultation should not only with interested persons in general and the ministers, but also it must specifically mention consultation with MECs of provinces and organized local government in the determination of norms and standards. We think that it is very important to entrench the need to consult intergovernmentally in determining norms that are going to impact this particular service. The other part of the Act, 103C, or the part of the bill 103C, proposes that any person, you'll recall what I commented about earlier on, it says any person, department, municipality, or provincial head may establish or operate a childhood development center. You will link this with our earlier comment on 103A, where we're saying any person can access funding to do this. This then entrenches that point that any person can actually get funding from the department, provincial department, in order to establish this center. If the department and parliament feels that it is best to do it in that way, that any person may, we want to suggest that in the minimum then, there must be a condition included in this section, which proposes that the establishment of such sectors must be on the basis of concurrence by the affected municipality. Concurrence which should be on the basis that the proposed establishment is in line with the IDP, is in line with the Spatial Development Framework, and it is in line with the bylaws of the municipality. So that we don't have a situation of uncontrolled pop-up of early childhood development centers, sometimes in areas that may not accord with the development plans of the municipality. We say that to that extent, we wish to suggest that that insertion be made in this particular section. Then there is the second last comment, or the second last comment that we want to make in relation again to this section, is that there is a section that is being introduced, which is called assignments of functions to a municipality. The section reads, the MEC for social development, by written agreement with a municipality, may assign performance of some of or all of the functions contemplated in sections 103D up to J to a municipal manager, and then it goes on after consultation with council and so on. The comment we would like to make in relation to that is that essentially if you read the content of that section, which says assignment of functions to municipalities, it is essentially about, it's not about assignment of functions to municipalities. it is about a delegation of responsibilities to a municipal manager. We think there's a difference between delegation of responsibilities to a municipal manager and assignment of functions to a municipality. When functions are assigned to a municipality, the municipality exercises those in terms of its executive and legislative authority that is vested on the council of a municipality. And then it is the council of the municipality that delegates functions to a municipal manager once the council has accepted responsibility for a function. This particular section seeks to delegate functions to a municipal manager as opposed to dealing with assignment of functions. We think, though, that it is important that in this particular bill or in particular act, we have a mechanisms of shifting powers and functions in relation to the performance of these functions. And that mechanism must be informed by an assessment of capacity, where province or district municipality or local municipality is assessed not to have the necessary capacity to perform the function. There must be a mechanism of shifting the function to where it can be best performed. We think that is absolutely important to do that. However, our experience is that when that is done on the basis of a subjective assessment by the MEC or by a minister, we've seen that in other functions, such as roads and transport, such as human settlements, that when that is done on the basis of that, we don't really see an objective management of the assignment of powers and functions, because as experts would say, powers and functions are about power. Hence they're called powers and functions. So it is difficult for the person who is in a position of power to relinquish power to another person and therefore render themselves irrelevant in relation to the powers of that particular function. So it becomes a conflict of interest in a way. We are then saying that let us have an assignment of powers and functions. However, that assessment must be done in terms of the provisions that are given to the Municipal Demarcation Board, because the board, in its own act, it is mandated to do assessment of capacity of municipalities. In fact, the amendment bill that is going through the parliament now of the Demarcation Board seeks to enhance the role of the Demarcation Board in terms of assessing capacity of municipalities and advising MECs on which powers must be situated. We think that we need to entrench that. The second part, we think that that decision, having been advised by the board, must make provision for it to be mediated by the National Council of Provinces. Because as we have seen currently with the interventions that are happening in municipalities, without proper mediation by National Council of Provinces, they are open to abuse because they are about power. So we want to propose that this act, this bill, must make indeed a provision for assignment of powers and functions between municipalities and adjusting of such. However, it must make provision for capacity assessment to be undertaken by the Demarcation Board, and also the decision be mediated at least by the NCOP, which is different from what is currently contained in the bill, which is about the delegation of responsibilities to a municipal manager. So to conclude, therefore, Chair.
Mr. Kolisa, Mr. Kolisa?
Yes, sir. Chairperson?
Mr. Kolisa?
Yes, Chair.
Can you go back to that part?
Yes.
Back to that part?
Yes, I'm there, Chair.
I just want to understand your narrative here. You are talking about two concepts, assignment and delegation. And I want to restate your story so that when honorable members respond, it's clear. I'm not sure if you are saying this is delegation, therefore it must be treated as such, or it was not supposed to be delegation, it was supposed to be assignment, therefore this is what you are proposing. Can you restate that, because it's a very important section?
Thank you, Chair. We are saying, first of all, the part that deals with early childhood development is essentially the same function that is in Part B of Schedule 4, which is about childcare centers. That's the first part, which therefore means that the Constitution has already allocated this function to local government. So it is not being assigned or
Which function?
delegated. The function of early childhood development, which in the Constitution is stated as childcare facilities.
Okay, it's constitutionally allocated. It's constitutionally allocated.
Yes, it's constitutionally allocated to local government
That's
by
right.
way of.
That is the assertion you made. That is the assertion. All right, then proceed, make your story.
Then we're saying that in the context of functions that have already been allocated to local government by the Constitution, we think that there is no need for the MEC to then delegate or assign such functions to local because they're already there.
Okay.
However, there might be a need to adjust between at least the local and district municipalities, the performance of those functions within local government, depending on capacity. Then we're saying that in respect of that part, we think the Act must make provision for the adjustment of which of the two between local and district, because in the case of the metros, it's there. There's no necessary adjustment. In respect of the two, which must perform. And then we're saying that in that sense, it must be informed by capacity assessments made by the demarcation board. We then also are saying there could be a case which is unlikely that a district, a local, or a metro may not be adequately performing this function because of lack of capacity. And then in that case, there is a need to shift the function and delegate or assign it to a higher sphere of government. We don't want to close that possibility, because what we have currently in respect of that situation is a temporal.
Repeat that possibility, Kolisa.
Okay, I'm saying, Chair, there is a possibility, which is, I'm saying, is unlikely, that for some reason, a local or a municipality, whether it's a district or it's a local or it's a metro, may not be adequately performing this function of childcare facilities because of lack of capacity, which might necessitate that there must be a shifting of that responsibility. As things stand, the Constitution allows for intervention on that function to take over and perform by a provincial government. It's already allowed for in the Constitution. But if there were to be a need for a permanent allocation of this function away from local government, as the Constitution says, then it must be something that must be mediated by Parliament, the NCOP, or even the shifting between locals and districts to minimize political conflicts. We think that it must be something that again must be mediated by NCOP. So I don't have a situation where one MEC, let's say for argument's sake, an MEC of one political party, which is aligned with a political party running a district, prefers to take away the function from a political party that is running a local municipality on the basis that there's alignment between the district and the province. There's no alignment within the province and the local. So we think that in order to minimize power play, let the demarcation board do the assessment, which we will hope it will be an independent and objective, and inform a recommendation that will be made by the MEC, and that recommendation be made to the NCOP in order for the NCOP to say, you may go ahead and make the adjustment of the powers. So we're addressing a whole lot. I think there must be a section that addresses a whole lot of possibilities of movement of functions between local and districts, and also if there is a need to shift between the spheres of government. I hope I'm making it clear now, Jim.
No, it's okay, members. I think I hear you. But members will actually engage you. Proceed.
Thank you, Chair. Then, on the basis of the points that we have made in the presentation, we wish to make the following two recommendations. One, in order to correct the constitutional procedure of dealing with this bill, that the bill be referred back to the department, for the department to publish it for public comment in a manner that allows organized local government and municipalities and interested people an opportunity to make representation before the bill is introduced to Parliament. Then that all of these views and the things that we have said, we have a way of proposing them by way of representation to the department so that they can be factored in. Because the alternative now would be that the points we're making about specific sections be points that Parliament may consider or the committee may consider and put into the bill, as opposed to the department engaging with us and we find the best way of presenting these points in the bill. However, if the committee feels that it wants to proceed, it's not really concerned about our assertion that the procedure of tackling this bill may be unconstitutional. We then say, as an alternative, then the committee will suggest that it considers the specific comments that we have made in respect of sections 103A, 103B, 103C, and 103K of the bill. Thank you very much, Chair.
Okay, we thank you, Mr. Kolisa. Honorable members, is there any addition from SALGA? You are being led by Councillor, what was the surname? Sadet?
Sidan, Councillor Sidan.
Councillor Sidel. Councillor Sidel, any further additions before the members can engage?
Very much, Chair. I think I am fine with the presentation. It was teamwork. Thank you very much.
Great teamwork. Honorable members, do you want to engage the presentation? I'm looking for the hands on the chart. Yeah, no, you will be engaged. Honorable Stock, Honorable Aris, Honorable Masango, Honorable Alexander, Honorable Akhbare Briet, Chrisman. Honorable Stock, it's your turn.
Thank you very much, Honorable Chairperson. Let me take this opportunity also to appreciate the presentation from SALGA. It's highly appreciated. Honorable Chair, I've got just three issues which I want to raise quickly with SALGA. And then the first one is that we need all the support to ensure that there is efficacy in the implementation of the bill. Stakeholders must work together to ensure that the child's best interest is at the core of their work. So I would like to find out how can the Department of Social Development and SALGA use the theory of change as a scientific tool to ensure that as a country, we optimally ensure that the child's best interest is at the core by implementing this bill. And secondly, I would like to find out if the task of deciding which tasks must be assigned to municipalities requires thorough discussions with municipalities. Does that mean that there has been no support given to ECD services? Subsequently, does that also mean that the legislative mandate of the municipalities as per Section 152 and 153 in the Children's Act of the Children's Act have not been implemented by municipalities? I would also like to find out as my last issue, when can the committee receive a detailed plan on how DSD as well as SALGA are going to address the long-standing challenges that exist between the ECD community and DSDV in totality, as this has a direct impact on the implementation of the legislation and the rolling out of our services to the ECD community. Thank you very much, Honorable Chairperson.
Thank you, Honorable Stock. Honorable Aris.
Good morning, Chair. Thank you very much. Chair, mine is just on the constitutional mandate. I want to find out how do you deal with the municipalities that do not fulfill their constitutional mandate in terms of their social programs? Because, Chair, what we will find out that in some of the municipalities, there are not even a single social, really, social department which are dealing with these ECDs and these things. And then the other one is just in terms of that one that they propose that that 103.1. My worry in this one is that they say this must be a condition that the proposed establishment is recommended by the affected municipalities as in line with the IDPs and SDFs and bylaws of the municipalities. My concern, however, on that one is that what if, because we have learned that with these IDP processes, that the community is not really, participate in these processes. I want to find out what alternative, apart from those people, those individual people that want to have their ECDs and, operational, that they must still, if it is not on the IDP, will that people then be excluded, even though they are rendering a good service to our communities? And I just want to find out what other alternatives, apart from being part of IDP and SDF, what other alternatives are there? Thank you, Chair.
Thank you. Honorable Masango.
Thank you, Chair. And thank you to SALGA for the presentation. I wonder if my questions should be asked to the department rather than to SASA in relation to this bill, because my questions are for clarity that the issues that were raised in this presentation as regards to the constitutionality of the introduction of the bill, the question I wanted to ask is it prudent for us to go ahead with the bill? Is it not going to affect the processing of the bill at a later stage? And most importantly for me, this bill is a response to a call for a comprehensive legal solution to the foster care crisis. So we do need to make sure that as we process the bill, it is at the end of the day going to respond adequately, in that the foster care crisis will be sort of alleviated, and that the children's best interest is at the center of what we are doing. So, and also the other question that I wanted to ask was that the program as we have it, in terms of how the bill will be taken out for public comment, the week that we have might not be enough to adequately engage for SALGA in this instance, to adequately engage with municipality. So those are the questions, Chair. I'm not sure who I'm asking them for, but I will direct them to you because you are obviously guiding us on this process, because I would hate for us to rush and then find that we are caught at a later stage to have not done what we were supposed to have done, and also not achieving what we are seeking to achieve with the bill in the first place. Thank you, Chair.
Abraham.
Thank you, Chairperson, and thank you to the team at SALGA for this presentation. Chairperson, my question is, how would, improved MOUs and SLA agreements with the various provincial departments and the municipalities help in this situation? Oh, sorry, Chair. Help in this situation. And also, Chairperson, the bill in its current format, in its proposed format, does SASA, do the local municipalities, would they have capacity to implement this bill? Would they have the budget as it stands now to implement this bill? What are those concerns and challenges they face? And then also, what is this last question? Chairperson, I think this one is more for you. I think at some point we're going to also have to bring in the MECs to come and present to us on their capacity and concerns when it comes to this bill, because as it's been pointed out, that a lot of the responsibilities and the functions actually lie provincially and not at local government level. And then just lastly to SALGA, this concern that there was, lack of participation between the local municipalities on this process. Is that the majority of the municipalities? Is it a small number of municipalities that feel that they weren't consulted? Just what is the breakdown of the municipalities who feel that they were not adequately participated in the drafting of this legislation? Thanks, Chair.
Are you done?
I have completed. Thanks, Chair.
Thank you very much. Honorable Abrams, akhbar breed.
Dankie baie, voorsitter. Chairperson, I think a lot of what my colleague said covered what I wanted to ask, and as specifically Honourable Abrams, I'm speaking to the capacity. My fear is also in terms of finances. We see currently, and I'm in the Free State, and I see that our municipalities and the state that our municipalities are currently in, they can't perform basic service delivery functions. My fear is, and as we've seen in the past, they do not perform their duties, the inspection of facilities and those functions that are constitutionally mandated by the Constitution for them to perform. And I would like to, and I understand, and SALGA has to an extent tried to build in the assistance of the MDB. But that is one of my greatest fears, and necessarily, as we've seen with interventions in the Free State specifically, is that a provincial government cannot get hold of that. How do they propose that we ensure that this happens when you have a failing municipality and your provincial government does not succeed in intervening there? And then in terms of Mr. Kulisi also, Kulisa mentioned that they would support additional funding to municipalities to be able to perform this service that is already constitutionally mandated. How would they envision this this additional funding going to municipalities? Would it be in terms of an additional amendment to the equitable share? Would it be in terms of a grant? How do they envision this going forward? Then, Chairperson, and I think one of the other members mentioned that as well, is in terms of, there's a lot of role players here in terms of your local government, your local and your district municipalities, also your provincial government, your MECs, and then also your DSDs, but also your different COGTA, and everybody needs to have an input. And we've seen that a lot of our departments do function in silos. There isn't that wisselwerking, to name the Afrikaans, that we see within provinces, within our government sphere as a whole, if I can call it that, on the different levels. How are we going to improve that? What is the improver? What is SALGA's suggestion for that? As I see, there currently is no MOUs or SLAs. And then, Chairperson, maybe just a comment on page 8. We mentioned that, and Mr. Kulisa said that we are hoping the MDB will be objective and that they will bring it in. I commend that we are looking at bringing more objectivity in, bringing more spheres of government in, and having councillors and opposition parties have a say. But my fear is, and we see it in the Free State, that the MDB is not necessarily more objective, But that is just a comment from my side, Chairperson, and I think I will leave it at that for now.
Baie dankie agbare breed, Honorable agbare Opperman.
Thank you, Chairperson. I'd like to know, Chair, how will this be rolled out in terms of the district development model of COCTA? And then I'd like to know what resources and infrastructure will be put in place in the relevant municipalities, and who will be the custodians of any money in terms of the assignment of functions, given the bad track record of most municipalities in terms of their own core mandate. And then I'd like to know what are the clear functions that DSD has assigned to municipalities, and how will municipalities enforce their bylaws to control emerging ECD centers when there is already a discrepancy between environmental health practitioners' set standards and those of social development? And most importantly, Chair, are municipalities ready to implement this bill? Thank you.
Thank you very much, Honorable Opperman. I'm advised that Mr. Kolisa, if you can stop sharing, maybe you'll bring it back when you answer questions. I'm being advised by the technical team this side. Honorable Opperman and Honorable Manganye.
Thank you very much, Chair, and thanks for the presentation by Mine, Chair, I just want to check, apart from the legislative mandate, how are the current?
Am I the only one who's struggling to hear?
You are not, Chair.
Am I the only one who's struggling to hear?
No, you are not. You are not.
The sound is bad. If the videos can be muted by those who are not speaking, please.
Even by those who are not speaking.
Yes, Chair, it interferes with the
Right.
sound, with the network. If those who are not speaking, except you, may unmute.
Who is giving this? Who's giving this advice? Who is giving the advice?
Honorable Chair, it was me, Nozibele Makanda, that when many videos are open, they tend to interfere with the network.
Okay. Now that you are a technical person, I will respect that. But the problem is that media people want to see our faces. But let's take, maybe let's respect that. We can close the cameras, but usually they want to see us as their protocol. Honorable Manganye, can you try to be clear? She's gone. Oh, she has left. That's what the technology is saying. Lindwe, can you try to interact with Honorable Manganye, maybe in a written form? Her questions can be raised. Is that okay?
I'll do so, Chair.
Thank you very much. Am I correct that Mjengane is around?
I've invited him, Chair, and I just called him. His phone is on voicemail.
No, I've seen him in the chat. I've seen him in the chat. It seems he's here.
Okay.
Chair?
Mr. Mjengane.
Chair?
Yes?
Chair?
Yes, yeah. Are you here, Mjengane? Yeah.
I am here, Chairperson. Good morning to you.
Thank you. Good morning to you. Can you be the first one to deal with the publication and constitutional issues? Can you deal with that one now?
Chair.
Before they come back. Who's calling?
Chairperson,
Who's
we
calling?
have a member Mutaung who wants to speak, and member Pilankulu forwarded a question for SALGA. I don't know whether I must read it.
No, but the problem is that member Mutaung, I could not see her on the chart. That's the problem. Let her speak anyway. Honorable Mutaung, come in.
No,
but it's not in the chart.
It is, Chair. Chair, please.
Yes.
Chairperson, thank you, Chair. My first question will be the issue of supporting, promoting, and sustaining ECDs is not only a DSD and SALGA issue. To what extent have both parties considered mobilizing communities to assist advance the legislative mandate on ECD? And then number two, Chair, have there been any intervention instituted to resolve the poor working relations between environmental health practitioners and social development ECD coordinators? If there have been any, what have they been and what improvement have they made to change the working relations? If there have not been any interventions, what have been the reasons and what plans are in place to start the process of mending the working relationship between the two parties?
Which parties, Honorable Mutaung? Which parties, Honorable Mutaung?
DSD Chairperson SALGA.
Okay, all right. Am I missing any other honorable member?
Chairperson, I have the question from member Pilankulu.
What is the question of honorable? Yes, can you raise it?
She forwarded the following question. The first one, noting that the underlying principle in the Children's Act is that the child's best interest is of paramount importance in every matter concerning the child. Have there been any attempts to ensure that despite the challenges that exist between DSD and municipality, this principle is upheld? The second question and last, why hasn't the DSD as the custodian of the Children's Act ensured that there be no memorandum of understanding or service level agreements in place between MECs of social development and municipalities? When will this be addressed? Thank you very much, Chair.
Lindwe, is DSD represented here?
No, Chair. I've just sent the link to Jessica for DSD if they want to observe the proceedings, because this is part of the consultation process for the committee.
I think it's advisable that they should always have somebody during these exercises.
Okay.
I think it's very, very important. It's just logical as far as I'm concerned.
Okay.
Mr. Mjengan.
Yes, Chairperson, I'm here.
There is an assertion by SALGA that before introducing this bill in Parliament, certain imperatives of consultations where local government would play a role are supposed to have been followed. Based on their view, they have got those recommendations, correct it, or alternatively, whatever. That's a legal issue and procedural matter. Can you speak on that?
Yes, Chairperson, thank you. Good morning to you and honorable members and my colleagues. Chairperson, SALGA is correct. When an executive bill, such as the one that is currently before the committee, is introduced, there is what is called a pre-introduction consultation, which takes place or which is conducted by the department. This is where, Chairperson, it includes a process that leads to a cabinet approval before an introduction of the bill. There is a consultation of interested and affected stakeholders, which is conducted.
Can you mute Honorable Mtau? Proceed.
Yes, Chairperson, I was saying that there is a pre-introduction consultation that takes place of interested and affected stakeholders that is conducted by the department. It is the one that SALGA is referring to, Chairperson, where they say that such a pre-introduction consultation did not take place. It is a process, Chairperson, that is steeped in intergovernmental relations. It's an IGR process where they are MINMAX, Minister and MEC's consultations, consultations with NEDLAC, as well as other key and interested stakeholders, Chairperson, which all lead to a cabinet approval for the introduction of the bill. All of this happens before, or is by right supposed to happen before the bill is introduced to Parliament, Chairperson. Parliament itself has its own public consultation, constitutional requirements, Chairperson, as you know. However, the consultation that SALGA seems to be referring to in its presentation is a pre-introduction consultation. And I believe, Chairperson, it is the department itself that can properly advise the committee the extent to which it conducted the pre-introduction consultation as is required in law, as well as the IGR processes to be observed in the executive. Thank you.
Can I ask a question?
Yes, sir.
If indeed the department hasn't done that, what are the implications?
In previous instances, Chairperson, committees have sent the department back to observe the steps that it is required to observe in law in order to limit any potential challenge, Chairperson, on the bill on the basis of illegality. Much later in the process while Parliament is dealing with the process, or even after Parliament has completed its process.
Okay.
When a aggrieved party to come through and state their their level of aggrievement by the lack of consultation, as has been alleged in this instance, Chairperson.
Is the alternative that is being proposed by SALGA a workable one?
Chairperson, at this stage, I would apologize.
Does that alternative address that problem?
Chairperson, my apologies. I have not applied myself to the SALGA alternative in order for me to decide if the authoritatively advise.
No, as they come, just look at their presentation. They are against this background. They say, we recommend that you follow the process, or alternatively, there's something to that effect. So I want you to look at their presentation and come back to make a comment on that.
Absolutely, Chair.
Councillor Sidel, thank you. Councillor Sidel, can you guys respond to the comments raised?
Thank you very much, Honorable Chairperson. Let me welcome the inputs and questions that were posed by honorable members. Indeed, they were insightful and eye-opening. However, Honorable Chair, I must indicate that we really feel at this stage, many of the questions that were posed, probably, I don't know, my technical team will be in a position to respond to, because we are a bit challenged given the fact that we concentrated more in terms of the amendment bill. However, as honorable members were making—
Which was correct.
Yes. So I'm a bit skeptical to respond to the other issues because they speak, or they are directly linked to the department. And I must indicate, Honorable Chair, probably this portfolio committee will also assist. We've made several attempts to get to the department through the MINMAX sittings. We've made requests that the organized local government is represented in the MINMAX so that we begin to address some of the challenges that were also posed by the honorable members, but we are not receiving any joy in terms of that recognition. Probably if the committee can also assist us to get the attention of the department, because really we feel if we are having that representation in the MINMEC sittings, we can be able to address many of the challenges that we're experiencing as SALGA, as well as what the honorable members has noted. But let me allow probably my technical team to respond to details in terms of the question posed, Honorable Chair. Thank you.
Just sorry, before you leave the platform, Councillor Sidia, is this not the principle across other departments? Are you not represented?
Honorable Chair,
Yeah?
safe to say for now, as far as this working group is concerned in SALGA, we are not participating in the MINMEC sittings, either than the COCTA MINMEC. But in terms of your sports,
it means all departments is not a practice that you are represented.
It is not, except for COCTA. But where I am responsible in terms of your community services, which social development forms part, and your sports department, we are not sitting in the MINMEC sittings.
I find it very interesting, because when I was in the short time I was in the treasury, in meetings like this, we had local government, if my memory serves me well. But however, maybe it's a matter that needs to be followed up, because I think where I'm sitting, unless it's legally precluded, your concern is genuine. Can we do this? To Mr. Kolisa, respond to the issues that deal with the amendments, with the legislation. Maybe our team will make sure that you don't respond to other issues that you didn't plan to, as long as you will advise who will deal with those questions. But the primary purpose of being here is to deal with the legislation. If you can respond to that extent, but if you are able to respond to others, you can. But I accept that the primary reason is amendment of the legislation. But however, one assumes that whatever proposals you are making as local government on this bill is informed by your experience at an operational level, be it tactical or strategic. That experience empowers you to assist in a useful way on how to go around doing this legislation. That is an assumption we take. Mr. Kolisa?
Thank you, Chair. Thank you, honorable members. Just to pick up from where Councillor Sidel left, I think the point has to be, is that I think the explanation is that in relation to what we can call community and social development functions, sports, and as well as social development, we still have challenges in being recognized and participate in the MINMECs of that as organized local government, despite the requirement of the IGR Framework Act, which requires that organized local government participates in MINMECs, where that particular MINMEC is dealing with functions that affect local government. But in terms of other departments, human settlements, for example, rural development, and others, we participate as local government, and in National Treasury, we participate in local government, for instance, the budget in the budget forum of National Treasury. So there isn't a common thing. And I think what members are then picking up is that due to that lack of implementation of IGR Framework Act in this particular department, you then have the situation that we're having now. Because had we been part of the MINMEC, we would have advised the department that we need time to consult municipalities and feedback to this bill before it goes to Parliament. I think there is that issue that we think, and we have actually written, the President of SALGA has written to the Minister of Social Development requesting that we be invited and participate in terms of the HR Framework Act. We have not yet received a response to that, except for the acknowledgement of receipt of that letter. That was in November last year. So that's there's that, and we're trying to pursue that issue. So there are the points related to that. I think they get to be answered. That there are efforts, and we think that also Parliament could reinforce those efforts, because it's absolutely important that as we perform the mandate of this function, we work together as the three spheres of government. There was a question about, are municipalities ready? Do they have financial resources? In my third slide of the presentation, I indicated what is it that municipalities are currently doing in relation to early childhood development. Others are even running early childhood development centers. However, having said so, I think I must indicate the fiscal framework of local government recognizes in the main two streams of funding of local government. The one stream is own revenues of a municipality, which is your property rates and as well as service charges of municipalities, which under normal circumstances, if we didn't have poverty levels as we have, every citizen would be contributing to that, and therefore the municipalities will have resources to contribute to those to the functions that municipalities deliver. However, the reality is that we also have poor households that cannot afford, and yet they must receive these services. It is the reason why then we have an equitable share of local government, equitable share that is allocated to local government in order to subsidize, that's the word that is being used, to subsidize the provision of services to households that cannot afford to pay the municipality for those services. That's so some of the services might not be chargeable services. There are services that are normally paid for through the property rates income. This is one of those that are paid for through the property rates income. So municipalities don't pay directly, except in some cases some small what we call fees for their children. But under normal circumstances, building this infrastructure, maintaining this infrastructure is paid from the property rates income. Now, for the households that cannot afford, the equitable share is supposed to contribute to fill in that gap. However, the structure of the equitable share currently does not include this particular function of early childhood care. It includes the 4 basic services, and we have managed to push it to include the municipal health service in the recent years. But it doesn't include, and this is not the only one. In fact, the other day we were in Parliament saying, if you look at the Constitution, local government has 36 functions. But if you look at the equitable share formula, the equitable share formula provides for 6 of those 36 functions. The rest of the 30 functions must be performed by local government using own revenue, even for the poor households, which leads to what we call becomes an unfunded mandate in that sense. So as we correct this to say we are asserting this local government function, we are also acknowledging that there is inadequate funding of local government in respect of this, which is why in one of our comments we are saying the funding that is identified that should be made available under 103A of the amendment. We are saying that that funding should be funding that could assist municipalities to the extent that in any case, this particular function, the national fiscus allocates money to provinces and national government and not to municipalities. That it could be a funding that is channeled to municipalities to support this particular function, which is otherwise not funded in respect of poor households. The question was raised by Councillor, by Honourable Honourable Oberman, of how can this money be channeled? I think, or it was Honourable Priet, and how can it be channeled? We're saying that provincial governments can make this a conditional grant to municipalities, which municipalities would apply for, meet the conditions, and implement. So there's a mechanism through which they can do that through their own allocations in the province. There are some cases where provinces do that in some of the functions, so it can be done. Then moving on to the other question, will MOUs help? Well, I think that question gets answered by what we are saying. Actually, let's strengthen IGR. In the existence of the IGR Framework Act, it becomes unnecessary for the spheres of government to be signing MOUs between each other because it puts obligations for all of us to cooperate. So we could just strengthen IGR and we answer the problems that we have. Councillor Mahlangu, how can we deal then with the consultation issue? I think we've made a recommendation that refer this back to the department. The department must be directed to go through the consultation process, and we will make inputs accordingly in that consultation process. Or alternatively, as we have said, consider these inputs here and amend the elements of the bill as we have suggested. But we think that we might be depriving this amendment process of much more fuller engagement in input if we don't refer it back, so that there could be much more engagement before it comes to Parliament. Councillor Aris, Honorable Aris, how do you deal with municipalities that are not performing the function? There is a process provided for when a municipality is not performing the function, which is intervention on that particular function and take over and run the function, which is not being done very well currently. It's something that the law provides for. Other than that, there is also a provision in section 154 of the Constitution, 155 of the Constitution, for government, national and provincial government, to support municipalities. We think that our recommendation in terms of this particular act, it starts to talk to that responsibility of supporting, and then when that support does not work, then there'll be intervention. So there is a provision. We should not have a situation where there is a municipal area in which this function is not performed at all and nothing is being done, because there is the obligations that emanate from the Constitution in terms of when that happens. But also on our side as local government, we support municipalities, we advise municipalities as SALGA on what are their functions. One of the things that we do right at the beginning of election of municipal leadership is to introduce them on all of the responsibilities of local government, so they know when they take decisions in council on budget, that they look at where we looked at all of the responsibilities of local government. Maybe let me leave it at that, Chair, without taking a lot of your time, to say a lot of things will be corrected by IGR, strengthening IGR. Secondly, if this is referred back, we can be able to make even more inputs, engaging the department and shaping this much more better. Thank you.
Thank you, Mr.
Chair, I was going to say you.
Can you come in? Oh, you wanted to say something, Mr. Kolisa?
I was going to say your mic is muted because I know you are not muted.
Okay, all right. Mr. Mshengane.
Yes, Chairperson. No, thank you. Chair, I have listened to the proposal by Mr. Kolisi, and also the alternative that you wanted me to comment on. Chairperson, the difficulty that the committee has, Chairperson, is that it is only SALGA for now that has come forward and forwarded its grievance with regard to the inadequacy of the consultation process. And the alternative that SALGA is proposing, that the committee must simply implement SALGA's proposals in the amendment process, will probably assist SALGA as the only entity which has come forward with its grievance. However, the legal process of consultation as an obligation on the department still persists, and other stakeholders may not come to Parliament with the problem, Chairperson. And in order to properly cure the defect, My advice would be for the department to be the ones that account for the process of consultation they undertook and the extent to which it complied with the legal requirements relevant. Thank you, Chairperson. So really, the alternative.
Do I understand? Did I understand you to be saying, Mr. Mjenglane? Can you hear me?
I can now, Chair. Yes.
I'm saying, do I understand you to be saying our process can? It is possible to correct that defect whilst our process is continuing.
I'm saying, Chairperson, to the extent that SALGA has put proposals on how to amend the bill, the committee can look into those proposals, and if the committee is persuaded, it can effect those amendments.
No. I want you to get me carefully. I'm not dealing with what SALGA has submitted. I'm not dealing with the alternative proposed by SALGA. I'm dealing with the material defect, which is a legal requirement. Did you say in the past that defect has been corrected by a department going to do that work, which was supposed to do? And I'm saying, if they use that way, that traditional way of correcting that defect, that presupposes, if I heard you correctly, that it doesn't stop us going, our process unfolding whilst they are correcting that.
No, Chairperson. The manner in which it has been done in the past, Chair, in practice, is that when the bill is referred back to the department for department to observe its legal requirements of consultation, the committee suspends its work on the bill in the event that to avoid any situation where by the time the department completes its work, there are further changes that need to be implemented on the bill. The only challenge, Chairperson, with that option here now of sending the matter back, the bill back to the department for the department to do what it was supposed to do, are the relevant time constraints, as the Chairperson is aware, that we are working on an externally controlled deadline in terms of the court order. I don't know, Chairperson, if the department has advised the committee to the extent that it observed the legal requirement of consulting the stakeholders, including SALGA. Perhaps the first step would be for the department to present to the committee how it consulted or how it executed its legal obligation to consult stakeholders. And on that basis, the committee could then make an assessment of how to proceed, Chairperson, in this regard.
If I'm listening to you, it appears rigid, because I thought there's a moment where you had some flexibility towards how it can be corrected. But your comment now comes with the headline, which seems to, I'm not sure whether you say it's coming from law, that the only way we can correct this is by pausing. Let us say, for instance, the department comes, which is urgent, and they tell us they didn't do this. The hardline legal position, if I'm listening to you, is just we must pause. Am I correct?
Yes, Chairperson, I am in essence saying that, Chairperson, that the legal obligation on the department cannot be corrected by the committee if the department did not observe the legal obligation. No.
Wait, Mjenglane. I want to. Sorry, Mjenglane.
Yes, Chair.
I want to communicate. Let's assume that the department tells us they didn't do this work. We're already in a process of public hearing. We're already going there. I am saying, if the department goes to correct what it was supposed to do, does it mean we should stop what we're doing until they finish what they are doing?
Chairperson, my direct answer to that is yes, because we cannot presume the outcome of a consultation process. because to continue to work with the public participation or to engage in the public participation process would presuppose that all of the consultation process will not effect any changes on the bill that the committee is consulting on. In other words, or put differently, Chairperson, if the bill is sent back to the department to do what it was supposed to do, meaning to consult the stakeholders, this could lead to some changes being effected on the bill that is before the committee. And the difficulty the committee would have if it continued to consult now on the bill as the bill is before the committee or as introduced is such that it would negate all of the consultation process that has still got to happen as conducted by the department in terms of the law. This is why, Chairperson, I was saying that perhaps the first step for the committee to do now after SALGA has raised the alarm would be for the committee to invite the department, for the department to present how it facilitated its public involvement obligations in terms of the law. And then for an assessment to be made from that.
Yeah.
And if the committee in its wisdom is of the view that the department did not fully execute its legal obligations as is alleged by SALGA, only at that stage can then the committee make a decision on the referral back to the department of the bill for the department to do what it is supposed to do.
Okay, maybe we should rush there and have the department speaking to this matter, because listening to you, there's a logical challenge, if I'm listening properly, that we may go to public hearings and ask people to participate in this process based on what we got from the cabinet.
Yes.
And yet the department's correction can lead to a new proposal, which those who would be participating during public hearing would not have had an opportunity to look at. Am I correct?
That is correct, Chair.
Okay. Wow. I wish I didn't hear that. Honorable members, do you want to comment on this? Because
Yes,
it's a straightforward matter that we should call the department to urgently clarify this matter so that we are on the right path. Can I close it at that point?
Okay.
Yes, Chair.
Thank you, honorable members. Thank you very much. Honorable Masango, yours is an old hand, am I right?
It's not an old hand, Chair, but I gather that you are saying we call the department and then raise issues with them, because I do have an issue that I thought I should also just mention while we have Mr. Mjenglane's audience with regards to this.
Okay, no. Then, Ms. Sabo, we need an urgent session with the department to protect this process so that we can fall within the timeframes of the court. And then at that point, can I express my gratitude to SALGA, because I guess we heard you on your proposal when you talk about funds being allocated to persons that you say the specific local government's name should be referred to there. That's your proposal. And again, on the norms and standards, you say it should not just be persons and whoever else and minister, it should also be ensuring that all other spheres of government are involved. And again, on the development centers, we speak about a concurrence of local government to the extent that IDPs are aligned with. And of course, the issue of assignment and delegations, you went to an elaborate extent on that. Am I presenting Honorable Councillor Sidel properly in my summary, but it's written? Is that okay?
Fine, Chair.
Yes.
Hello?
We're okay, Chair. Thank you very much.
Councillor Sidel? Thank you very much. Thank you for your participation. We'll stay in touch with you guys. A bill is a process, it's not an event. Processing a bill. There might be instances where we call you to come back. I'm sure you will bear with us on that. But we must thank you for drawing our attention to this aspect of procedure and chronology of events and so on. We thank you, Councillor Sidel, your team, and everyone else. Thank you very much. You are released.
Thank you,
Thank you very much.
But we don't have a problem. Thank you very much. The next item, urban members, is a concept paper by our content advisor with regard to some conceptual framework on how we take the process forward. Is Yoli there?
I am here, Chairperson.
Take the platform now.
Thank you, Chairperson.
Am I correct that the document was circulated amongst the members?
It's correct, Chair.
Thank you very much. Proceed.
Okay. Thank you, Chairperson, and good morning to you. Good morning to the honorable members and to my colleagues and other people in this platform. Chairperson, I'm just going to share it quickly. Okay. Can the members see the presentation? Can I proceed? Can you see it? Okay. Chairperson, this presentation is on the concept paper that the committee will have to look at it and consider the options and scenarios that are highlighted in this concept paper. And to start, Chairperson, I would like to table the table of contents, and also maybe just as an introduction, just to have a request through you, Chair, to say, I know the members have seen the concept paper and it's actually a comprehensive paper, but I would like to only focus to the main purpose of it, because the first part of the paper really deals with the summary of what the bill is and when it was introduced to Parliament and the briefings that we had, which I want to believe that members are familiar with those sections. So I would like to really look at the main purpose of this concept paper. So to say that, Chair, but I won't maybe neglect just to mention the legal provisions for the children's right. And the key proposed amendments are just there I just put it here because they are in the paper, but I won't go into details about that, Chairperson. I will focus a little bit on the key concerns emanating from the bill, that some questions that maybe members have had a chance to look at in the concept paper that I just had in mind as I was listening to the proceedings since the bill was introduced to us, and including the briefing that we just had earlier on. There is one bullet that speaks to that. And then, Chairperson, I will also look at so far what processes have unfolded since the bill was introduced, and also look at the guiding principles of processing the bill. At this point, maybe, Chair, I can just mention that yes, I did at the part of the concept paper as far as it relates to the concept, to the content of the bill. But I didn't work alone. I also used information from the Parliamentary Public Education Office, and also from Parliamentary Communication Service. And I think the colleagues are here. So when I get to that space, Chair, I will have to beg for indulgence from the committee, from members, that is not an area I'm very much familiar with, but because I have to present it, I will just give what I know, but the nitty-gritty details and questions and explanation that members may have, I would really request my members from those offices, my colleagues from those offices, to assist me. I don't want to say the wrong thing, because that area is very critical, because it speaks to the actual public participation and mobilizing the public. So they are better off in terms of addressing any concerns or issues that the members may have. So that speaks to now the next bullet in terms of the options of public participation. That's exactly what I'm talking about, and involvement of these offices. Okay, I've already, I think, alluded to what the purpose of this positive paper is, but just to make it clear, it is really to put forward a framework to guide the committee in terms of when it's conducting this public participation process, and it outlines options that will ensure a reasonable public involvement. It also, by doing so, it gives various scenarios and options in the context of the period that we are currently under, which is the COVID-19, and as far as the protocols that need to be observed in terms of us being on level 3, adjusted level 3. Then I will also speak to the advantages and disadvantages of those scenarios, and where possible give recommendations. Okay, Chair, that's the essence of what this paper is about. Just to give a legal framework in terms of where this bill is located, South Africa is a signatory of the Convention on the Rights of Children, of a Child, the African Charter of the Rights and Welfare of a Child. This framework, they really give protection in terms of the rights of children, and also give principles or provisions against discrimination of children, and particularly a girl child. We also have our constitution, which the presenter before me kind of like highlighted as far as SALGA is involved. So the constitution also makes provisions in terms of the rights of children to parental care, to alternative care where the parental care can be exercised, and other provisions related to the services for children. We also have the Children's Act, which the members of the committee are quite familiar, which this bill aims to amend. And I might just mention, Chairperson, that this is not the first amendment that was done on this Children's Act. In 2016, the committee also passed amendments, 2 versions of amendments of this bill, of this act, which I'm really don't go into detail about. I'm just mentioning it that this is another amendment to the Children's Act. We also have the Social Assistance Amendment Act that mainly speaks to the Social Security Net or the Social Security Program, which are your social grants. Those are legislated on this act. These are just the legislative framework behind this bill. Can I just maybe jump this slide, Chairperson, because this mainly speaks to what the bill provides, which I think the members are aware of. Okay, Chairperson, just to go zoom in into what I said earlier in terms of the areas that the committee, as it proceeds with this bill, should just have these questions in the back of their minds that I kind of like taken as I was listening and taking notes to the engagements that we have as a committee so far. So the one, I don't confess to have any answers, I don't. I'm just flagging these that the members may just have in the back of their mind. One will be the big issue that we have in terms of the migration of the ECT program from DST to DBE, and what would be possibly an impact in terms of the implementation of this bill. We don't really know what are the timelines in terms of this migration process, and when it does, what implication it have. Maybe it may coincide with the implementation of this bill. What may be the potential impact of that? And is there a plan to manage that potential impact? And also to address any potential disruptions in the provision of the ECD services and resources. It's just a question that I'm flagging to the members to have in mind. Does the bill provide an adequate legal solution that will ensure that foster care orders do not lapse in large numbers again, creating another backlog? Have capacity challenges both administratively, that is in relation to the department in terms of the social workers, and the judiciary, the children's courts, that caused the backlog, have they been addressed through these amendments? Mm-hmm. The other one, Chair, it relates to what we discussed last week with the department in terms of the capacity of the department to perform the adoption service. We had a discussion last week in the state of readiness, and in the light that we having challenges with other child protection services. One would be your foster care. The other one, Chairperson, also relating to the adoption process, which I picked up as I was listening last week. To what extent does the bill adequately address all the complexities related to the adoption processes? For example, challenges in obtaining the identification documents from the Department of Home Affairs, the accessibility of the service, it came out last week from the members, the bottlenecks in the system that cause delays, and any potential implications, legal implications between those countries that are signatories to the Hague Convention and those that are not. And any other processes that I have not listed here that the department may be more aware of than I am. Okay, the other one, Chair, is that in the past, there have been instances where one department will draft a bill and goes to the parliament, it gets passed, and only to find out that it actually affects the function or a piece of legislation either within that department or with other government departments that will now need to be repealed or amended. Okay, if there's that possibility, that in my mind, I was thinking of the provision on child marriages that is legislated in the bill that is under the Department of Home Affairs. That's just one example, Chair. Okay, now we just had a discussion on the capacity of municipalities to implement this. I won't go into detail. The presentation before me even highlighted even more challenging issues that the committee will have to deal with. And just to say, with this question, the main or overarching question that the members or the committee will have to really think about is the bill implementable. Take into consideration that it has been amended before. Would there be a need to further amend this? Is there a way that as a committee we can maybe try and eliminate that from happening? But I know that services change, that situations change, that may lead to the bill being amended. But as far as this bill is concerned, and as far as the committee can eliminate it, is it something that can be done? Okay, Chair. Now to go back in terms of how this bill has been processed and will be processed going forward. The bill was tagged in Parliament or recommended as a Section 76 bill. And that is a bill that affects both the province and the nation, that affects the provinces. And that bill can either be introduced in the National Assembly or in the NSOP. But the two houses must consider the bill. And in our instance, the bill was introduced by the minister on the 31st of August 2020, and we received a briefing on the 6th of October 2020. Then emanating from that briefing, the committee made a resolution that the department should come back and give a little bit of detail in terms of the provisions regarding adoption services. That took place last week. Then this week, today, we had a briefing from SALGA. There is a briefing that is scheduled for the Home Affairs Department or Minister on the 3rd of March. And then there will also be a briefing by the Minister of Basic Education, speaking on the issue of migration of ECD and the impact it may, or possible impact it may have on service delivery. That is coming on the 16th of March. And just to mention that then from this meeting, then there will be a follow-up now with the department with regard to the consultation process. And then as far as the public involvement, Chairperson, when the bill was introduced last year, an advertisement was done on the bill. And as per the requirements, it was at a 3-week duration from the 16th to the 27th of November last year, where the interested parties or the public were invited to submit written submissions. And also they were also asked to indicate if they will be, or if they have an interest or they want to come and make other submissions. So we are currently now in that process, Chairperson, as the team and content team of analyzing the submissions in this month of February, because January was mainly people were on leave, and only like in February where we were all like back as Parliament staff. So we started with that process now in the month of February. And also to say that the Office of the PEO and the Parliament Democracy Offices, they commenced their process of mobilizing the public in November already, and it hasn't stopped. They are continuing with that process, Chair. Then going forward, it looks like my process is back and forth, but that's how it is structured in terms of our process. The public hearings, as the committee approved the program last week, we will have provincial public hearings on the 9th to the 12th of March. We will have the national hearings, which are now mainly oral submissions for those who indicated that they will want to come and present their submissions, on the 17th to the 19th of March. There is a 3rd week, Chair, that was mentioned, but that is subjected to approval from the powers that be in terms, because it falls within the constituency period. So I didn't include that one here, Chair. And on the 16th of March, there will be a presentation from me on the key issues and proposals drawn from the submissions, because from what we have analyzed and summarized as a team. Then only now, after we are back from the constituency period in the 2nd quarter, the committee resumes, where we will have a discussion on the key issues and clause by clause. Then we'll have the finalization and adoption of the report on the bill also during that period, Chairperson. That's just the process, Chairperson. Now I'm getting into the crux of the matter in terms of the framework or advice in terms of the guide in terms of public participation. But just to mention that the Office of the Public Education, in their consultation or public awareness, they really adopted the guiding principles as identified by UNICEF, and they included in this concept paper. But the main principle is that of ensuring the best interest of a child, and that is of paramount importance. And the principles that they had to apply as stated here, Chairperson, in terms of the process should be transparent, that the children are able to participate in this process. It is informative, that they get all the information that has to do with the bill, that the children are able to participate voluntarily. They may withdraw in the process whenever they decide, and they must be respectful that their views are expressed freely, and that they are also considered in decision making. It's relevant, that it addresses the needs and protection of a child. It's inclusive in the sense that it also, the process includes the children who may be marginalized or discriminated for various reasons, and they should be supported by adults, and should be done in a friendly manner, a child-friendly manner. And most importantly, Chairperson, where maybe there's a need to mobilize children, that their safety was ensured, and any risk that may arise, that there were services or resources there to assist, as well as the process to be accountable in terms of whatever the children they feel that needs to be considered, it is considered, Chairperson. So this is the framework that was used in the consultation process by the Office of the Public Education of Parliament. Now to go now, Chairperson, in terms of the options that are available or the committee will need to consider in terms of public participation in the context of the COVID-19 period that we're in and the lockdown restrictions in terms of adjusted level 3. There are two options, Chairperson, that are advanced here. One is that of hosting a virtual meeting for public hearings. The second one, which I'm going to speak to it later on, is about organizing regional workshops of 50 participants, because that's what the protocol, disaster management protocols for this level dictate, Chairperson, must not be more than 50 people in a social gathering. Back to the first option. The first option, Chairperson, it's about conducting public hearings through this platform that we're currently using, either using Microsoft Teams or Zoom platforms, and that the committee must make sure that these proceedings, the public hearings, are broadcasted in different parliamentary channels and social media platforms. Those are listed here, your YouTube, your Facebook, Twitter, and DSTV. Also, Chair, that the committee will have to decide on the number of district municipalities to participate per province, because now we're not going to go into, if we use this platform, that we're not going to have physical visits to the provinces. Based on the previous committees that had conducted these public hearings virtually, the recommended number is between 3 and 4 districts per province. And these will be selected based on the research on the geographic profile of a district in relation to the bill. That will be done by the contact team to make that the determination, or at least advice or guide. Then also the committee will have to decide on the number of participants per day, as well as number of days of public hearings. That, Chairperson, as we adopted the committee program last week, the committee secretary presented that program to the committee and the committee adopted it. Okay, and then the committee also will have to decide on the following options in terms of how it will conduct the public hearings on the day. Conduct public hearings per district or per number of districts for each province. Allocate a day per province, or 2 or 3 days, or 2 or 3 provinces per day. Now, if you look at this option, Chairperson, the second one, actually both, the advantage of option 1, that is allocating a province per day, is that it will give a committee more time to engage with that province and more participants. The disadvantage is that, Chairperson, it would mean that the committee will have to set aside 9 days for both the national and provincial public hearings, each or individual, if I can put it that way. And let me just speak to the second point, Chair, before I mention this. The advantage of the 2 or 3 provinces per day, we can just finish this, is that the committee will have reduced time in terms of the number of days and would have a reasonable number of participants. The disadvantage is exactly that the committee will have less days to conduct public hearings. Now, having just mentioned that, I want members to just be cognizant of the fact that our program is guided or dependent on the parliamentary program. So when the committee staff, secretariat draft a program, we have to take into consideration the overall parliamentary program and how it is allocated slots for committees. In the sense that certain days are for plenaries, because a constituency period.
You can send me, can email me,
Can
I am
someone
in a
mute,
meeting
please?
at the moment, and I will.
Aye. 1 second.
I think it's Honorable Masango.
What going on?
Okay, it's sorted, Chair. It's sorted.
Okay, proceed.
Yes, okay. So that also, this advantages and disadvantages also applicable to bullet number 1 in terms of choosing per district or a number of districts. The other options that the committee may consider is still on the virtual platform, is to split the membership into 2 groups. That was done before, but not on this platform. It was done when the committee will go to the provinces, like physical visits there. So split the membership of the committee into 2 groups, as well as the provinces. And on this option, Chair, the advantage of it is that still it will, still within that, what I just said in terms of us being guided by the parliamentary program, it will limit the number of days for public participation because now the provinces would have been divided. However, the disadvantage of that is that each group of members, there will be a risk of not having a full complement of the committee secretariat or support group, because we won't be able to be, for example, I'm the only content advisor. There's only one committee secretary, there's only one researcher that I'm talking about. So we can't be in both, all of us in both groups. So that's the disadvantage of this option, Chair. Then we have, as I said, the other option now, which is not on the virtual platform, is that of organizing regional workshops. These are but to adhere to the 50 participants as per the protocol. Then it will mean that these 50 people must include the 11 members of parliament, the committee support team, the media crew, and communication. And that can be, those workshops can be conducted at public venues agreed upon. And that will mean then members having to travel to the provinces, but having workshops of 50 participants. On this point, Chair, I couldn't put that whole table here on the slide presentation in terms of the whole advantages and disadvantages of the options that I just presented. And they are on page 12 of the document that I forwarded to members. But just to say, Chairperson, when it comes to, I'm just gonna summarize them just for the sake of the presentation. As far as the advantages of the virtual platform is that all interested stakeholders can connect, into the platforms. The risk is that of lack of infrastructure or poor connectivity to the members of the public, especially those in rural areas. When you look at the regional workshops, the advantage is that the committee will have a face-to-face engagements with the stakeholders, but the disadvantage that the numbers will be very limited, only 50 or even less, because that 50 must include the members of parliament or the whole group from parliament, including the support staff. In terms of the virtual platform, another advantage, Chairperson, is that all members can follow proceedings on parliamentary media channels, or they'll be connected to that. Also, again, the risk is that it may include a large number of people from the poor or those who have connectivity issues. If you look at the regional workshops, Chairperson, the advantage is that because the number is limited, bearing in mind that the number of actual stakeholders will be even more limited, but in terms of adhering to the protocols, it may make it easier for adherence to the protocols. But then the disadvantage is that members will have to travel now to the provinces, to the gatherings. The other one, Chairperson, as far as the virtual platform is concerned in terms of the advantages, is that there are no travel risk or in terms of spreading of the COVID-19 through public hearings, if you do it virtually. But the disadvantage or the risk is that members of staff organizing participation of members of the public are at risk because they have to go to organize those to the provinces. In terms of the regional workshops, Chair, the advantage there is that community representatives can be assisted to attend the workshop through the office of the PEO and the PDO's, public democracy offices. Also, the risk of spreading of infection in terms of the COVID-19. So just a summary, Chairperson, of the risk, the advantages, disadvantages, and all that each scenario or option pose. Chairperson, just to now go to the actual, what will public hearings entail in terms of the virtual public hearings? Like I said, we have allocated 2 or 3 weeks of public hearings. That's the bullet number 1. Number 2 is that mobilizing of teams. There'll be teams that will be identifying members of the public who are interested in making oral submissions. And that is mainly done by the office, the PO office and the PDO in liaising with the committee secretariat. Then there is involvement of the PCS, Parliamentary Communication Services, in terms of using the print or electronic media. I don't want to go into all the details that are listed here, but basically they will be facilitating the communication between the committee and the public, as well as public involvement as far as making like radio stations and all the other platforms that the office uses, that they may go into detail. I'm not very comfortable to go into detail because it's not my space, Chairperson. So we're having the PO, the PDOs, and the PCS to assist us, Chairperson. They are here to give our members clarity or answer questions that may arise. That's the end of my presentation, Chair. Thank you.
Thank you very much. Yoli, do I understand you to have put scenarios, implications, and making a proposal of what should be done? Can you make a comment to that effect?
Yes, Chairperson, I've put those scenarios, and my recommendation would be, because it has been done before, that we use a virtual platform. We spoke with the people who, the PO's office, for example, who have assisted with other committees to conduct this kind of public hearings, Chair.
It looks straightforward to me, honorable members, questions, whatever.
Thank you, Chair. And thank you, Yoli.
Yes.
Sorry. Thank you so much to the content advisor for this presentation. And it has actually helped to concretize the questions or questions for clarity that one needs to flag. The first one being the mention of the migration of the ECD from the migration of the ECD from...
You disappeared almost. I will start afresh, please.
Okay, thank you, Chair. Am I audible now? Hello?
We can hear you.
Okay.
Yes, ma'am.
Yes, the first question is the migration of ECD from DSD to DBE, and the fact that there is, if I'm not mistaken, a what they call a BELA bill, the Basic Education Laws Amendment Bill that is going on, and how that affects our process as the portfolio or as the Department of Social Development, and how then making sure that at our meeting with the department, we actually look at that, we seek support in actually clarifying if we actually do need to go through this process, if the Department of Basic Education is also doing the same thing about the Bella Bill. And the second one is just for me, clarity. I don't recall the National Assembly doing provincial public hearings. I just need some clarity on that, because even as the bill is being processed, there is a process that will ensue from the National Council of Provinces. So I just need to understand how that is going to be why we are discussing provincial public hearings at all. And the other thing that I wanted to also raise earlier is that the presentation by SALGA, I needed to understand from the chair that the defect, or that we talked about constitutionality or unconstitutionality and so forth, only relates to the ECD sections of the bill, and does not taint the entire bill, as it were, so that the other provisions are constitutionally compliant, and therefore, with the exception of the ECD that we need to discuss what to happen to it, then we can go ahead with the other sections of the bill, as it were. So that those are the issues I wanted to raise, Chair. Thank you so much.
Thank you. The next is Honorable Dikhan.
Thank you very much, Honorable Chairperson. Let me join other colleagues as well to appreciate the presentation, which was done by the content advisor. But I just want to raise, I think I'm clear about the options that have been presented to us, the risks involved, the advantages, the disadvantages, and all of that. But I think in the last portfolio committee meeting, we posed a question to, the content advisor and the team, that in case you are going to host a virtual public hearing, what does that mean? What does it entail? How is it going to happen? We even asked a question in that meeting, if my memory serves me well, that for an example, in a province, if it's virtual, does it mean members of parliament will be in our different constituencies in the provinces, or do we have to Cape Town and all of that? So can you please elaborate and explain to us as to how is it going to take place and all of that? And then the second thing is that today we are still on level 3, advanced level.
No, sorry, Honorable Stock. Can you, Honorable Stock, can you start afresh? I just want to follow the concern, please. My apology.
No, thank you very much. No, Honorable Chair, I was saying in the last portfolio committee meeting, when this thing of the public hearings on the bill was presented to us, there was a proposal from the team that due to COVID, we must consider the option of doing public hearings on virtual. Now, the question we posed to them the last time was that if we're going to do it virtual, which all of us, I think we're all scared for our lives in our different areas where we are. We don't want to go out and confront and get the virus and all of that. So, but we posed a question to the team that in case we go the virtual option, what is going to happen? How is that going to, practically, how is that going to take place? And then we even said to the team, go back and consult with I think it's public education office and all of that, of the legislatures and of parliament, as to how are we going to do this thing. So I think that clarity is not getting out clearly from the presentation of the content advisor. If I can be clarified on that one, I'll be very happy. And then the second thing is also that what if we agree on virtual today, on a virtual public hearing, and then 2 days or a week down the line, and then the president takes the country to level 2. What implication will it have on our decision? Thanks.
Yeah. Yes, Honorable Van.
Thanks, Chair. I'm also concerned. I think the two honorable members that have spoken, I have the same concern in terms of the presenter, that is Uyoli. She is talking about the province, which in my thinking, it has never really happened on that way. Because what is supposed to have been done is this thing of going down to the level of the grassroots. So on how are we going to do that one? Are we going to do the public hearings at the level of the province? But I heard her also talking about the district. At the same time, she mentioned 9 days that is needed, which is 9 provinces in my thinking. And what is it that is going to happen in the district then? And how are we going to take down the information to the level of the locals? That's my concern. Otherwise, all others are really clear. Thanks, Chair.
Thank you very much, Honorable Vana. Honorable Aris.
No, Chair, thank you. I'm covered by the previous speakers. Thanks.
Akhbare Abrams.
Thank you, Chairperson, and thank you to the Content Advisor for the presentation. Chairperson, I'd just like to find out when will the committee receive a breakdown or summary of how many submissions have been received per province, how many organizations, individuals would like to come and make oral submissions, how many of those people, do not have access to the Zoom platform and therefore will need to be assisted in that regard? Because my assumption is that once we have those numbers and those figures, we would then be better informed as to which of the options will work for this process. And then also, Chair, I'd just like to find out, has Parliament considered then also looking at hybrid models in the same way we have our hybrid sittings of Parliament, that if we are present in a venue, that those who do not have access to connectivity can come in while still listening to those who do have access to make those virtual submissions. So I'd just like to find out those 2 points, Chair. Thanks.
Baya danke. Gone. Yoli?
Person, I'm here. Okay.
Yes, go for it.
Yes. Okay, Chair. Chair, I'm going to give answers, and then I will request my team, especially from the PEO and PCS, to really assist me where I have a weakness in terms of the members wanting to know in terms of how exactly are these virtual public hearings will be conducted, and what does that entail. In terms of the migration of the ECD, I'll take that Honorable Masango was just raising that it must be noted because we will have a briefing from.
Yeah.
Yes, so it's just something to note. Okay, Chairperson, in terms of Honorable Mvana and Mama Sango's concern about provincial hearings, members, if you can recall last year, before when we were in level 1, the committee had agreed that we were going to go to the provinces and conduct public hearings. It is done. The NA committees, they do go to provinces and conduct public hearings, Chairperson. Then that's what we're talking about. But because if we do it on the virtual platform, Chairperson, the people these public hearings are mainly for like the general public, not necessarily people who submitted their submissions to us. So when we go there, we speak, like we go to a venue where all the members of the public will come to those public hearings, and we speak to whoever is given a platform on those hearings, Chairperson. That's what the provincial public hearings mean in terms of the NA committees conducting them. So it is done, Chairperson. It's just that now, because of the restrictions, we're having this challenge of numbers. I don't know if I'm making it clear. Then we have the national public hearing that we're talking about here, Chair. Those are the people who indicated when they submitted their written submissions that they want to do oral presentation. I don't know if I'm making it clear, the two the hearings. One is a public hearing where everyone ordinarily, if we had gone to the provinces, would have participated. The other one is for those people who had submitted the written submissions and they asked to make oral submissions on those submissions. That's what we're talking about as national hearings, Chairperson.
Don't you have, wait. Don't you have similar people at the provincial level who apply for oral presentation?
At the provincial level? Chairperson, what happens is when looking at the submissions. Sorry, Chair? The written submissions that we have in terms of oral, they're open.
What I'm saying, if I hear you, you're saying, when you say now, wait a bit, just listen carefully now. I thought you're saying national, you mean people who apply for oral submission, irrespective of where they come from. But I'm asking a question.
The line is not clear, it's breaking.
Are you suggesting that there are no people who do oral presentation at the...
Oh, Chair, I missed you there. The line is breaking.
Have I disappeared or has Yoli disappeared?
I think you disappeared, Chair. I don't know about the other members. I couldn't hear you.
I can hear you now. Can you hear me now?
Yes.
Can you hear me now?
Yes, Chair.
Can you?
Yes, I can.
I'm saying you were explaining that national means those people who would have requested oral presentation. Do you hear that part?
Yes, Chair.
Now my question is, are you suggesting that in a provincially focused approach, are there no oral presentation? How do you distinguish?
There is oral presentation in the provinces, Chairperson, in the sense that people will be mobilized to come and make presentations. If I can explain it, Chairperson, if we were to go to the provinces, for example, you come to the Western Cape, the team will have organized the people, and then we have a certain venue where we all go as members of parliament and people who come and make presentations or inputs or comments on the bill. Yes, Chair. Now, that's what would have happened as, like we say, provincial hearings, but conducted by NA committee. Is that what you're asking, Chair? Okay. Is it clear?
So, and then make a difference between that and those who are doing national?
Those ones, mainly those chairperson would have been maybe like an organization that made a submission, or even an individual that made a submission. Okay, so for example, in our case, we have about 2,200 of written submissions that we have received. So then there are say a certain number of those people who had indicated that they want to come and make a presentation on their submissions. So that one, Chairperson, I can put in that it's a bit limited in terms of it's only for those people who had indicated when they were submitting their inputs that they want to make oral submission, whereas the public is just open to the public. Not necessarily that.
So those who have made those requests, you classify as national.
Yes, Chair. But this is Lindy, if I'm not doing a good job, you can explain. I don't know. Are you clear, Chair?
Can you continue clarify?
Okay.
Deal with other questions.
Okay. The question on the constitutionality, unfortunately, I'm not able to answer that one, Chair. Yes, I'll leave that one. Implications of the change in the lockdown levels. Oh, that's a good question. I didn't really think about, unless colleagues from other units can assist me on this one. I didn't really apply my mind on that one, Chair. How the public will be mobilized? Can I just ask maybe the colleagues from the PEO to please come and explain in detail how is that done? Because I don't want to say
before
something.
the PO comes.
Yeah.
Before the PO comes, Linda, are there issues that you want to clarify?
Yes.
Yes, Chair. First, I want to make a correction with regard to the presentation on the publication of the advert for the bill. Yoli omitted and said it's 3 weeks. It was advertised for a period of 6 weeks. I just want to make that correction. I will attempt to answer the issue raised by Member Stock to say if in 2 days' time the President can announce that we are on level 2, what will be the way forward? I'll assume that a committee took a decision based on the lockdown regulations that we need to conduct this public hearing virtually. I think it will be in the same breath where the committee would need to revise its decision, whether they continue to conduct the hearing virtually or they want to go physically to the province. If they change the decision to go physically to provinces to conduct the hearings, it will mean that we need to make an application again for approval for such and give us time for preparations and consultation with various provinces to mobilize people to go to those public hearings. I think so. Chairperson, my manager's hand is also up when she's done. Maybe he wanted to also assist in this regard. Mr. Bandi.
Mr.
Bandi, Chair.
Banzi.
My manager is Mr. Bandi.
Bandi, okay.
Mr.
Bandi, please.
Maybe you want to assist.
No, your boss. Oh, your boss.
Yes,
your
Chair.
boss.
Yes.
Come, Mr. Bandi. Come, please. You need your help.
Thank you, Chairperson. Good day, honorable members and colleagues. Thank you for this opportunity. Chairperson, I wanted to elaborate on what the content advisor said with regard to national versus provincial. By the way, I joined you halfway. By national, we're referring to submissions that were made in response to the national advert, calling for submissions from members of the public. And then provinces obviously will refer to those submissions, including oral submissions, as you inquired earlier, that will be made during the submissions during the provincial public hearings. Yes, provincial public hearings will also include districts. It's just our way of structuring the submissions. When we talk of provinces, we're trying to ensure that we cover as many people as possible from all corners of the country. That means people from various districts, as the committee will deem fit to choose which provinces to visit. There was also the issue of virtual and the question.
No. Before you proceed, Bandi, I hear you are saying national means people will be responding to a national advert. When we deal with provinces, what shall they be responding to?
With regard to provincial public hearings, the committee will take a decision on which provinces to visit. Whereas with national, these are people who express interest.
In other words, you are saying generally people who respond to a national advert will deal with them nationally, but when you say provincial, we mean if we go to Mpumalanga, the people who respond to us going to Mpumalanga, those are provincial people.
Yes, Chairperson. And
All
there
right.
will be people who will be making oral presentation in Mpumalanga. Thank you.
Okay, no, it's fine. All right. Okay. Proceed, Bandi.
Chairperson, the issue of whether a virtual or a hybrid meeting, the committee must decide. The content advisor and the team proposed that a virtual meeting be considered in line with what the PC on Agriculture with their bill chose, with the direction that the PC on Agriculture chose. Yesterday, Parliament for the first time confirmed that there are two venues that are now available for hybrid meetings. The venues are E249 and another venue in the NCOP building. So the committee can decide whether they prefer a virtual meeting or virtual public hearings, or whether they will go for hybrid meetings. Hybrid meetings may entail that those who are able to come to the venue in Parliament will be allowed to. Those who can't will participate virtually. But the choice should be the committee to take. Thank you.
All right, proceed, Yoli. Or is sorry, PO and PCS. Are there such people who want to assist? Are they here to assist those who are doing public education, what to call, in preparation for these hearings? Are there people who want to explain things based on the questions raised? Nyekoba has already spoken. All right, you want to come back, Nyeko?
Chairperson, I've just lowered my hand. Thank you.
Okay, thank you. Yoli, are there final things that you want to clarify?
Yes, Chair. There is a colleague from the PO's office who attempted to say something. Mr. Jacques Verster.
Mr. Who?
It's Dr. Jacques Verster. Thank you very much.
Mr. Who?
I'm speaking on behalf of Jacques Verster.
It's Meneer Verster.
Doctor at the moment, thank you. But whichever is more easier to pronounce, it doesn't matter. But
okay.
Thank you.
Sorry, Dr. Verster.
Worked hard for it. So you kind of, yeah. So there we go. The title is entitled to it, if I can put it that way. Thank you very much. Unfortunately, the management side from PO have been tasked at different directions, and Mr. Tulani or Mr. Madlala is unfortunately off ill at the moment as far as the communication given to me. The question concerning how mobilization takes place, I can only speak on past practices that have been taken. We do rely quite heavily on the provincial legislatures. For this reason, during our first engagements with the committee officials, we have requested that letters be forwarded as soon as is convenient to the various provincial legislatures across the country in order for their public education counterparts to be released to assist. We do follow protocol before one enters into a province. With the same process, then we do enter into the municipalities using the provincial legislatures. Quite often the vehicles used will be the community development workers, as well as councillors. Ward committees will be used, NGOs will be used. So we do rely quite heavily on the provincial legislatures databases, as well as our own, which have been developed as we have engaged with members of the committee. For instance, we did start the process with the written submissions. So quite a few of those stakeholders do want to participate in the oral submission process. So in a nutshell, we use our provincial counterparts as well as to engage with municipalities, and we are also highly dependent on individuals such as the SALGA speaker at national level to release provincial individuals. So, but from a most basic standing point from the legislative sector, we work alongside the provincial legislatures as is past practices. But obviously, I cannot hold the office to any specific statement. These are just opinions based on past practices, as the management might have a different viewpoint. Thank you very much. I hope that assists.
Baie dankie, Doctor. My understanding, honorable members, it is not the duty of the parliamentarians to burden themselves with a lot of technical logistics. My understanding that the interest of parliamentarians, they want South Africans to be given the best possible opportunity to interact with the bill. Then the technical work and logistical imperatives, technical people must assist the committee to achieve that goal. That's my understanding. Ours is the best possible opportunity given to our people to participate in this legislation. Yours as technical people is to make sure that you use your technical skills under the circumstances to achieve the best possible way of doing that under the circumstances. Is my summary understood? I'm talking to technical people.
Oh, sorry, Chair. I thought you were talking to the members.
No, members, I'm also speaking to them, but I want technical people to check if they understand what I'm saying. I'm saying to you, the interest of the members is to make sure that our people get the best possible opportunity to interact with this process. And technical people assist us to achieve that goal using their technical skills under the current conditions. That's all we expect. I don't want to be involved in a lot of other things. Am I understood?
Yes, Chair.
Yes,
Chair. You are spot on.
Yeah. Thank you very much. Honorable members, do you have a different comment from what I've just said now?
Can I?
No, Chair, no. That's true.
Thank you very much.
It's just that we wanted some clarity in few other things. Thanks, Chair.
Thank you very much. Yes. Otherwise, once you get involved in technical, no. Tina, sifuna bantu bethu participate. Yes, thank you very much. So, if that summary is agreed, okay. If that summary is agreed, if any honorable member feels that there is a threat to that participation based on what has been proposed, they can raise that issue now, because we want to close this so that technical people can go and do their work. But the biggest question that must be answered before we go all out is this urgent meeting with the department to tell us about this this technical glitch which SALGA has put before us, because that one would actually confirm the finality with regard to where we go. There being no, Honorable Van, I see your hand.
And my chair, sorry, I didn't put it up. Yolisa.
Okay, yes, Yoli.
Just one question from Honorable Abraham's chair. She wanted to know when the analysis of the submission is going to be presented to the committee.
Yes, answer that question, please.
Yes,
thank you.
I did indicate in my presentation on the 16th of March, Chair.
Okay, thank you very much. Because if you don't answer Honorable Abraham, so you will have to answer. Thank you very much. Honorable members, I thought that's the last item in the agenda. Lindy, am I correct?
You are correct, Chair. Can I just make a little bit of update regarding to a recommendation taken this meeting? Whilst you were in this meeting, tried to speak to the department to bring to their attention that they are urgently required to appear before the committee. The set time is for next week, Wednesday. We will just have a briefing from the Department of Home Affairs, and then we can put the department in as the second agenda item. So I'll email them this afternoon. And then secondly, Chair, just to clarify, just one item, because there were stakeholders who were here in our meeting. The program stated that on the 2nd of March, we will receive the briefing from the basic education as well as the DSD. That meeting will be on the 16th, so that I just want to clarify that maybe some concern or confusion. So the meeting will be on the 16th. Thank you very much.
Thank you very much, honorable members. As always, I must express my gratitude to this very productive and participatory and peaceful, harmonious committee, which is very effective, by the way. At that point in time, no one responds. Honorable Stock, can you hear me?
I can hear you, Madiba. We're under your leadership.
So the meeting is closed. Thank you very much.
Thanks, Chair.
Thank you.
Bye-bye. Bye-bye.
Bye, Chair.
Thank you. Thank you.
I'm going to end the meeting for everyone. Thank you very much.